what would happen if the non-citizen showed up to the right time and place in response to the notice of hearing, but the NTA had been incomplete? Would that be grounds for the non-citizen objecting that the entire proceeding was invalid? Because after all, the statute does say, this following information shall be provided. So if the date and time was omitted from the initial one, would that be grounds for an invalidation of the proceeding?
No, Justice Barrett. All of the courts of appeals that have considered that issue and the board, when it has considered that issue, has said that the requirements, both the statutory requirements and the regulatory requirements regarding the notice to appear and the information it has to contain are claims processing rules. They are not jurisdictional rules. So they do not divest the immigration court of jurisdiction if there is information missing from the notice to appear.
So is your position, let me try to state how I don't think you say it quite this way in your brief, but this is what I take from your brief, and I want to see if I'm understanding it correctly. A notice of hearing presupposes that there has been a notice to appear because otherwise, well, both because of the word change, and otherwise there would be no way for the alien to receive it because you have to know what address to send it at or have personally served it, correct?
That's correct.
Okay, so is it your position that once the notice of hearing arrives telling the non-citizen where and when to show up, even if there's some information lacking, and let's say it's information that's even maybe more significant than the date and time that the government has been omitting, and it's maybe an incomplete statement of the grounds for removal, that the alien, by virtue of the in absentia provision, has an obligation to show up because he's on notice. It's not like he's not aware that he is in contact with, immigration and that there are removal proceedings underway. But he has an obligation created by the notice of hearing to show up, and at that point to register any objections he may have to the incomplete NTA.
That is our position, Justice Barrett. I want to make sure that I'm clear, though, that we think there are a number of safeguards that would prevent the result that you're talking about or the blank document hypothetical that the other side has raised. And if I could go into those protections. The first is the regulatory requirement that the notice to appear contain the charging information. So if we had a blank document or a document that was missing the charges against the non-citizen,
don't you need the protection from the statute itself? Because the regulatory requirement can be subject to change. So I think your better argument comes from the clear and convincing evidence requirement in the statute itself.
That was my second response, Your Honor, which is we bear the burden by clear and convincing evidence to prove that the non-citizen both receive notice and that they are removable as charged. And so if you have a document that lacks charges, we could not prove that the non-citizen actually is removable. And then the third—
I'm sorry.
Well, the third protection I was going to refer to is the fact that in absentia removal is not automatic. There is an immigration judge who is sitting on the other side of the bench and who has to review the documents and decide whether in absentia removal is appropriate. And so I think it is highly unlikely that an immigration judge in the circumstances with the blank document or the document without charges would enter in absentia.
Suppose the A1 notice didn't have the right to counsel in it.
So the answer, I think, is the same as before. We view the right to counsel information obviously as an important piece of information, but the lack of that information does not affect the validity of the proceeding. So if the
right, so it does suggest, you're not informed of your right to counsel. Nonetheless, you have to show up. And I don't see that any of your safeguards actually protect the alien, the non-citizen, in that situation. What's going to prevent the non-citizen from being ordered removed, not being able to reopen, notwithstanding that he's never been told that he has a right to a lawyer?
What prevents that result, Your Honor, is the regulations I was referring to. If the notice to appear does not contain the information about the right to counsel, that is an incomplete notice to appear that would be rejected by the immigration court. I also want to emphasize
counsel,
that—
let me.
But maybe put most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal, national means. Why does, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation. And certainly it's not unusual that questions of national importance come up.
Well, I suppose this court would be saying something along the lines of that a state has the power to do it. But I guess I was asking you to go a little bit further and saying, why should that be the right rule? Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation?
Because Article 2 gives them the power to appoint their own electors as they see fit. But if they're going to use a federal constitutional qualification as a ballot access determinant, then it's creating a federal constitutional question that then this court decides, and other courts, other states, if this court affirms the decision below, determining that President Trump is ineligible to be president, other states would still have to determine what effect that would have on their own state's law and state procedure.
Well, I mean, if we affirmed and we said he was ineligible to be president, yes, maybe some states would say, well, we're going to keep him on the ballot anyway. But I mean, really, it's going to have, as Justice Kagan said, the effect of Colorado deciding. And it's true. I just want to push back a little bit on, well, it's a national thing because this court will decide it. You say that we have to review Colorado's factual record with clear error as the standard of review. So we would be stuck. The first mover state here, Colorado, we're stuck with that record. And, I don't want to get into whether the record, I mean, maybe the record is great, but what if the record wasn't? I mean, what if it wasn't a fulsome record? What if, the hearsay rules are, one-offs? Or what if this is just made by the Secretary of State without much process at all? How do we review those factual findings? Why should clear error review apply? And doesn't that just kind of buckle back into this point that Justice Kagan was making, that we made with Mr. Mitchell, too, that it just doesn't seem like a state call?
3 points, Your Honor. The first is that ordinarily, of course, this court reviews factual findings for clear error, but President Trump made the point in his reply brief that sometimes on constitutional questions that require a uniform resolution, this court can do something more like a Bose Corp-style independent review of the factual record. And we would have no objection to that, given that the record here, really the facts that are disputed here are incredibly narrow. The essence of our case is President Trump's own statements that he made in public view for all to see.
But then that's saying that in this context, which is very high stakes, if we review the facts essentially de novo, you want us all to just watch the video of the ellipse and then make a decision without any deference to or guidance from lower court fact-finding? That's unusual.
Well, ultimately, President Trump himself urges this court to decide the merits of his eligibility on the factual record here at page 2 of his brief. He's never at any point in this proceeding suggested there was something else that needed to be in the factual record, any other witnesses that he wanted to call to present his case. And again, the essence of our case is his own statements, and in particular, his own videotaped statements on the ellipse.
Thank you.
Justice Barrett?
So the general rule is that absent rare circumstances, state courts and federal courts share authority. State courts have authority to enforce the Constitution, but there are certain limits to that, certain situations in which the Constitution itself preempts the state's ability to resolve constitutional questions. And, Tarbell's case is one, and you said earlier that once a president is elected, you accepted that a state couldn't do anything about that. Like Colorado couldn't enact its own, say, quo warranto provision and then use it to get the Secretary of State or the president or anyone else out of office. And I assume that's because of this principle of structural preemption. Am I right?
Yes, Your Honor.
Okay. So I just want to clarify what that means for your argument. That means that your eggs are really in the basket of the Electors Clause, really in the Article 1 basket, because you're saying that even though all of the questions that people have been asking have suggested that there's a problem with giving a single state the authority to render a decision that would have an effect on a national election. But you're saying that those structural concerns, which might otherwise lead to the kind of result that you would accept after someone is in office, are overcome by the Electors Clause.
Absolutely. States run presidential elections. That's very clear from Article 2. once states have selected the electors and the electors have voted, states have no more power over the candidate who has been then nominated for president. But until then, the states do have the power to adjudicate those issues.
Thank you. Mr. Fletcher, so I did watch all of these videos and try to figure out exactly what this looks like. And I just want to ask you about this bump firing thing. So what if I designed something and I call it a bump band? Because I gather you can do this with bands and you can do it with your belt loop. So what if I designed and market something I call the bump band to help me turn my semi-automatic, in the same way? Why wouldn't that then be a machine gun under the statute?
So we think that's still not functioning automatically because that's not a self-regulating mechanism. My understanding is that what those devices do is they help the shooter keep their trigger finger still, but the shooter still has to manage the movement of the rifle back and forth, hold it so that it moves backwards just the right distance in just the right direction, then hold it again so it moves forward in just the right distance in just the right direction. And what makes a bump stock different is that it's a device that is built for just this purpose. It has the finger ledge that holds your finger in place, but then it also has a sliding function built in so that when a shot is fired, the recoil automatically pushes the rifle back, lets it disengage from the trigger so the shooter doesn't have to manually release it, and then allows it to slide forward again just the right distance in just the right direction.
Maybe Mr. Mitchell can help me understand from his point of view what that means, because it seems like it helps you do it better and in a more stable way, but that it functions the same way. But the other question I have, look, intuitively, I am entirely sympathetic to your argument. I mean, and it seems like, yes, this is functioning like a machine gun would. But, looking at that definition, I think the question is, why didn't Congress pass that legislation to make this covered more clearly? I think your argument depends on volition, right? So let me give you a hypothetical and then tell me if you think this satisfies the definition of machine gun. Let's imagine someone builds a fully automatic machine gun, and I won't try to come up with the technology for exactly how this is going to happen, but they install a tripwire on their property, and they just leave the gun there unattended, walk away. Somebody trips the wire, and then it begins shooting lots of rounds.
Yeah.
Does that satisfy your definition of a machine gun?
I think it does, yes.
Why?
Because a single act, and I think we've used different words like volition. I think the idea that we're trying to get at is, does some separate act, is that required, some manual act required for each shot, or is a single continuous act resulting in the firing of multiple shots? That's an unusual way to activate a machine gun, obviously, but I think even if it's a tripwire, that's still one act by a person that initiates a multi-shot fire.
But it's an unintentional act in the same way you might say if your finger, because for the bump stock to work, you still have to have your finger right there, right?
You do, yeah.
And it according to the Fifth Circuit, what you're focusing on is the definition. It looked at it from the perspective of the gun and the machinery of the gun, but you still do need your finger there to kind of pull back the trigger the same way that you would if it was volitional.
So not quite, actually, Justice Barrett, and I think this is important. When, in the typical way that you fire these bump stocks, and this the Fifth Circuit acknowledged at 21A of the petition appendix, you don't initiate firing by pulling backward with your trigger finger. The trigger finger stays completely stationary.
Push.
You initiate by pushing. And what the expert said and the district court found is you could replace your trigger finger with a little plastic post attached to the bump stock, and it would work in exactly the same way. So it's true that you have to keep your finger there, and if you moved your finger away, the bump firing sequence would stop. But that's a pretty trivial additional piece of input from the shooter. Really, what's starting and continuing the sequence is the push forward.
Thank you. Ms. Hawley, can I take you back to the affidavits and some of Justice Kagan's questions? You were talking about Dr. Francis, and as I read her allegations, or as her affidavit reads, she said that her partner was forced to perform a D&C when there was a living fetus, and she said she performed a D&C on a woman who was suffering serious complications. But the fact that she performed a D&C does not necessarily mean that there was a living embryo or fetus, because you can have a D&C after, a miscarriage. So if that's right, I think the difficulty here is that, at least to me, these affidavits do read more like the conscience objection is strictly to actually participating in the abortion to end the life of the embryo or fetus. And I don't read either Scott or Francis to say that they ever participated in that. So do you want to address that?
Sure. So first, Justice Barrett, I think Dr. Francis's combined with CMDA can be read for the broader conscience harm. Again, that's how the district court understood that. I'd point you to pages 7 and 8. That's how both the state panel and the Fifth Circuit understood respondents' conscience harms to extend beyond simply requiring the ending of an unborn life. And with respect to even the more narrow conscience harm, to whether a doctor may need to end a life, we think there's still a substantial risk of that occurring. If you look at the numbers of the increase from 7 to 10 weeks in gestational age, that means that 3.1% of pregnancies will be ongoing, requiring a DNC. We know at ROA 870 that 55% of those DNCs occur in the emergency room. This is a substantial number of women suffering abortion drug harm. Again, Guttmacher says 650,000 women took the drug in 2023.
But not all those DNCs will involve a pregnancy that would otherwise be viable or an embryo or fetus that would otherwise be living, because you can have complications or excessive bleeding even after the abortion is complete in that respect, but there's pregnancy tissue remaining.
So with the 3.1, Your Honor, is ongoing pregnancy.
Is ongoing
yes.
pregnancy.
And FDA says at JA 542 that up to 7% will need surgeries to stop either bleeding or ongoing pregnancies or failures.
How many members of your organization? You have a broad number of, doctors that are in your organization. I gather dentists, some doctors who are retired. How many members of your organization are OBGYNs who practice in hospitals who might be called into these ERs?
There are hundreds of them, Your Honor, but I think, may I finish? Sure. I think in particular that the named plaintiffs are OBGYN hospitalists who spend most of their time on the labor and delivery floors, but also are called to the OR to treat these sorts of emergencies.
Justice Barrett.
General, I want to ask a clarifying question about the distinction in the government's charging decisions between C1 and C2. Actually, let me make that stronger, not charging decisions, like what you could charge under the statute. So as you pointed out to Justice Kavanaugh just now, C1 has this additional mens rea requirement, but there is overlap. If you read otherwise obstructs, influences, etc., broadly, it would encompass, frankly, even on the other reading, it would encompass things like alters, destroys, mutilates, etc. But you wouldn't have to prove the extra mens rea. I thought I heard you say, and I just want to clarify to Justice Jackson earlier in the argument, that the government could not charge an alteration, mutilation, concealing a document or physical object under C2. Am I?
That's correct. We usually charge the specific paragraph, and so if the conduct fits within C1, we would charge it under C1, and that would be the proper place to locate the charge.
And is that charging, is that prosecutorial discretion, or do you think the statute would permit you to charge it under C2, thereby escaping the specific intent requirement?
Well, let me say that there is a specific intent requirement under C2, so there's no distinction between them in that regard. Right, it's the intent to obstruct the official proceeding. So you're right that we wouldn't have to prove intent to, mutilate a document or something, but we would still have to show the intent to obstruct the proceeding. This is pressing on, honestly, what's a difficult question about means versus elements, and I think the best reading of the statute is that these are different elements because they have these different actus rei, they have the different mens rea requirement, the mens rea requirement that's specific to C1. They each independently prohibit attempts, but it's a hard question ultimately. And if we charged under the wrong paragraph accidentally, I think we could usually say that was harmless error or else recharge under the correct paragraph.
Okay, let me ask you a question that kind of gets at some of the same points that Justice Alito's questions were getting at. So what if on January 6th, the Capitol itself had not been breached, the protest is going on outside the Capitol, stop the steal, police are, in megaphones saying disperse, disperse, they're too close to the Capitol, their goal is to impede, stop the proceeding, stop the counting of votes. Does that violate the statute in your view under this impede language?
So I think that one relevant question would be whether we could satisfy the nexus requirement and show that actually the natural and probable effect of that conduct would be to have some effect on what's going on in the Capitol and in the mine run.
You can.
Yes, so if you're assuming that the same thing happened where Congress had to go into recess and couldn't hold the joint session after all because there was such a security risk, I think that that probably would be chargeable if we had the intent evidence. Now, as I mentioned before, even with respect to the riot that happened, which was a much more serious breach, we don't have that evidence of intent for everyone. But if we had, for example, organizers where it was absolutely clear that they were the ringleaders who had intended to obstruct and undertook the action with that specific intent and did so knowing it was wrongful, and especially if they went, you know, I'm assuming you're saying they're in the unauthorized area right outside the Capitol, that is unlawful conduct committed with consciousness of wrongdoing if we have the proof of it.
Let's say that I am having a hard time accepting your limiting construction of the verbs obstruct, influence, or impedes to have this extra element. Tell me why I shouldn't be concerned about the breadth of the government's reading, just relying on corruptly and the nexus requirement. Should I be concerned, or could you just embrace it and say, yeah, there might be some as-applied First Amendment challenges or that sort of thing? I mean, can I be comfortable with the breadth if that's what I think?
Yes, you can be. You certainly don't have to agree with us that a de minimis hindrance wouldn't qualify. If you thought that this was unqualified and swept broadly to any kind of hindrance whatsoever, there would still be really important limits in the statute. Obviously, you'd have to have the official proceeding. I think the nexus requirement could be somewhat harder to establish in a circumstance where you might not think that the natural and probable effect of the conduct is going to be to obstruct the proceeding. You'd have to show that the defendant knew that the natural and probable effect would do that. You'd still have to show the corruptly mens rea. And as you mentioned, even if you could show all of that, if it were a circumstance that really did infringe on First Amendment rights, there would always be the backstop of an as-applied constitutional challenge.
Do you think it's plausible that Congress would have written a statute that broadly? I mean, let's say that I think that Justice Alito's example of the protesters in the courtroom, you know, let's say it's corrupt. It impedes the proceeding because we have to go off the bench and things are stopped. Let's say I think that that's covered by the word impedes, and there's the nexus and it's corruptly. Is it plausible to think Congress wrote a statute that would sweep that in?
Yes, I think that there are a lot of legitimate ways to try to voice your dissent if you disagree with what the court is doing, but one of the ways you cannot do it is come into this courtroom, halt the proceedings, force the justices to leave the bench, and do it with the intent and the corrupt mens rea. I think that Congress could think that is a severe intrusion on the functioning of our government and want to protect against that. And again, the 20-year statutory max, of course, is just a max. There's no mandatory minimum. So Congress would have recognized that sentencing courts would use their discretion to tailor the actual sentence to the facts of that specific offense.
Thank you. How do you define a community? So Justice Alito was describing how New Jersey has so many tightly woven municipalities close together. And here, you know, the Chief Justice was asking about whether if grants pass, if there was a new homeless shelter with lots of beds right across the border 10 minutes away, you know, could that be taken into account? And I think there was some back and forth and not necessarily agreement on that. What is your position? How do you define a community? Take that example of a homeless shelter right outside the limits of Grants Pass.
Yes. So to answer that hypothetical first, I'm not concerned. I don't have any problems with saying that a homeless person in Grants Pass has legal and physical access to a shelter that's just over the lines, if that's in fact true. Lots of jurisdictions limit their homeless shelters to people who are residents. And just to be clear, there was no suggestion in the record here that there were any shelters available outside of Grants Pass.
Understood. But so community doesn't need to be determined by jurisdictional lines, is what you're telling me, as a matter of the, because let's see, I'm asking all of this because in response to Justice Sotomayor, you were pointing out that our nation has a history and tradition of not saying you can shunt homeless people or the poor out of your jurisdiction and onto others. So, or out of your community and onto others, is I think how you phrased it. So I'm asking, how do we know what those lines are? And you're saying it doesn't have to be jurisdiction specific.
No, I think jurisdiction matters because that tells us kind of the lines in which whatever ordinance or statute applies. So when shelter is available, the ordinances are enforceable because they punish the conduct of not going to the shelter as opposed to the status of homelessness. So I think that a municipality can punish the conduct of not going to a shelter that's just over the line if you have physical and legal access to it. Now, for the reasons you say, and this dates back to our settlement system at the founding era, a lot of municipalities do not allow allow people from outside of the jurisdiction to use their shelters. And so under those circumstances, the shelter wouldn't be legally available.
Is that cruel and unusual punishment for them to turn away someone who wants to use their shelter?
No, that wouldn't be punishment. Punishment is the infliction of suffering for a crime.
Counsel,
Well, then why is the Eighth Amendment implicated in this case?
Because here we have fines and jail time. We have a status-based punishment scheme that is, in fact, inflicting punishment within the meaning of the Eighth Amendment.
Counsel, do you want to, I'm sorry, Chief.
No, I'm done. That's fine.
Do you want to address some of the line drawing problems that we've been going back and forth? I mean, Justice Gorsuch pointed out, eating is a basic human need, and it's not the case that soup kitchens or social services will always be able to meet it. And so he asked about whether the Eighth Amendment would prohibit punishment for stealing food. You might ask the same questions about trespass and squatting in structures if they're, if that was the best alternative. So how do we draw these difficult lines about, public urination and that sorts of things?
So I'll start with stealing food. Stealing food is not part of the definition of homelessness, and it's also not a universal attribute. So I would put that outside the scope of any of the arguments we're making here. With respect to public urination and defecation, if you had I don't think this would ever exist, but if you had a law that said homeless people cannot urinate or defecate anywhere within city limits, I think then it starts to look like this case. But if you're saying that people can't urinate or defecate on public property, it's hard to imagine a situation where
To go. So a homeless person, there's no facilities available, and a homeless person has no place else to go.
you might have there are commercial establishments. I don't know that anyone's pointed to a jurisdiction where you truly don't have access. But if we
what's the constitutional principle?
Right.
Take my hypothetical. Say there's not commercial establishments, don't want non-patrons coming in to use the facilities. There are no public facilities, and it's a generally applicable rule that says no public urination.
So I think one distinction between urination and defecation and sleeping is that sleeping outside is part of the definition of homelessness, right? Homelessness is lacking a fixed regular nighttime address. So the sleeping prohibition goes more directly to the status of homelessness than urination or defecation.
So it would not violate the Eighth Amendment to punish public urination and defecation.
You might come up with some different theory, but it's not the theory that we're
not the
putting
theory
forward in
that
this
you're
case.
okay.
Yes.
Justice Barrett?
So let me follow up on that. So you're saying there are services available, there's treatment available, so people would ultimately move off the street? Is that what you're saying? Because I think part of the premise of all of this, right, is that there are not enough beds for homeless people to occupy, and so there will be a mismatch, and there are going to be some people who can't be cared for. Are you saying that if your law is enforced, there is a way for everyone to be cared for?
No, I'm saying that's a policy question that is quite difficult, but these laws are an important part of the puzzle. They're not the only solution, and we don't believe that they are, but we think they're an important tool, and without them, we've seen what's happened on our streets. We've seen that people are dying in encampments. We've seen that cities are being forced to cede all of their public spaces. So that ultimate question is for the legislature and policymakers to figure out what the right solution, what the right mix of policies is. But the wrong answer is to do what the Ninth Circuit did here and to constitute.
Let me just interrupt you there. You're right. It's a very, very difficult policy question. And I asked you before about whether this was just about blankets or whether it went into having fires or urinating and defecating outdoors and that sort of thing. And Justice Sotomayor pointed out that this particular injunction did carve out those things and was just talking about sleep. But, other cases have been litigated in the Ninth Circuit that have gone beyond that. And because the line is things that are involuntary, that are human needs, it can extend. It's difficult to draw the line. And whatever we decide here about this case is about the line. So can you describe for me some of the things that are difficult to figure out about the line? They're sleeping with blankets. What else?
Public urination and defecation, that is a serious problem. Those are parts of biological necessities of being human. A court in Sacramento addressed that, and the Ninth Circuit's opinions debated whether its rule would actually reach those things. I think any rule that we are wondering about and debating whether it would go that far, I think that is a sign that it is not a workable rule. The slippery slope here is very real. It's not just for camping and conduct that might be a biological necessity, putting aside tents and fires in cold climates. What other things would be allowed? All of the things that a human needs to survive, for example, potentially come into focus under the Ninth Circuit's rule, but also in other areas. Someone could say that my drug use or possession is the other side of the coin because I'm an addict, or because a person who violates other laws could say that I had a compulsion to do those things that I couldn't control. And the plurality opinion in Powell addressed that very thing and why it's so important to draw the line there. And when conduct is involved, and once the court gets into deciding which conduct may be excused under the Eighth Amendment, it is so far afield of what the Eighth Amendment was ever understood to address.
Okay, speaking of status and conduct, you've argued that Robinson was wrong and we don't need to overrule it, and I agree. I don't think we should overrule Robinson. You've also been kind of resisting the status, you've been resisting characterizing anything other than the drug addiction that was at issue in Robinson as status. So what if the law said it is unlawful and punishable by 30 days in prison to have the status of homelessness? Just go with me. Just assume that the law defines homelessness as a status and it is a status. Would Robinson say that that law is unconstitutional under the Eighth Amendment? Would you concede that?
And you're saying that that is a status?
Yes, the law defines it as a status, and it's a status.
Well, yes, and I think it looks a lot like Robinson under that hypothetical, but of course we disagree that it is.
I understand you disagree, but you are accepting that Robinson draws a distinction between status and conduct, and you're just fighting about the definition of a status?
It draws the line where a law has no actus reus, so I think that's the easiest line. I don't defend the line under the Eighth Amendment because I don't think actually that the court, I know the court didn't rely on any Eighth Amendment principles or
But the hypothetical I just gave you had no actus reus either. The status of homelessness. I mean, it could be, 4 o'clock in the afternoon and the person is just standing outside the bus stop. Do you agree that if the law prohibited that, made that a crime, that under Robinson, whether Robinson was right or wrong, that under Robinson that would be a violation of the Eighth Amendment?
Well, I think the better framework is due process.
I understand that. Under Robinson, do you agree that that would be wrong?
Yes.
Okay. Thank you.
Justice Barrett?
Mr. Dreeben, I want to pick up with that public authority defense. So I'm looking at the OLC memo that David Barron wrote that you cited in your briefs. And he describes the public authority defense citing the model penal code. There are a few different definitions, but I'll just highlight this one. Justifying conduct which is required or authorized by the law defining the duties or functions of a public officer, the law governing the armed services or lawful conduct of war, or any other provision of law imposing a public duty. That sounds a lot like dividing a line between official and private conduct. I think it's narrower, and I recognize it's a defense, not an immunity. But when you look at the definition of it, are you acting within the scope of authority conferred by law or discharging a duty conferred by law? I think it's narrower than Blasingame, narrower than Nixon versus Fitzgerald, but that's what it sounds like to me. Do you agree or disagree?
Justice Barrett, I certainly understand the intuition that when you act outside of your lawful authority, you've kind of gone on a frolic detour, you're no longer carrying it out. I don't really think that that quite works for presidential activity. The only way that he could have implemented the orders is by exercising his commander-in-chief authority over the armed forces or his authority to supervise the executive branch. Those seem like core executive acts to me. There is such a possibility as an unlawful executive act.
I'm not sure that I understand your answer. I mean, I was thinking, it seemed to me that in your briefs and today, when you referred to the public authority defense, you said that's one of the built-in protections and why immunity is not necessary. Because in some of these instances, when the president takes such actions that, the court's been asking you, might this result in criminal prosecution, you say, well, he could raise this public authority defense. And so I'm saying, isn't this public authority defense, if raised, doesn't it sound like a defense that says, well, I was authorized by law to discharge this function?
And therefore, I acted lawfully.
Therefore, I acted lawfully and
Yes.
I'm not criminally liable.
Correct.
Does that involve a look into motives? Kind of gets to what Justice Gorsuch was asking you. Could you say I was acting within the scope of my authority by granting a pardon, removing a cabinet officer, but then the public authority defense might not apply because you had a bad motive in doing so?
No, I don't think so, Justice Barrett. I think that it operates based on objective facts disclosed to counsel. Counsel then provides the advice, in this case, the Department of Justice, and it's an objectively valid defense. It's a complete defense to prosecution.
So what would be so bad? I mean, one thing that strikes me as different, well, one thing that's obviously different between the public authority defense and immunity is an interlocutory appeal and having it resolved at the outset. What would be so bad about having a question like that resolved at the threshold, having it be an immunity? The same kind of question that could be brought up as a defense later, but have it be brought up at the threshold as an immunity, and then an interlocutory appeal would be available, and it would be a freedom from standing trial, but not a get-out-of-jail-free card.
Yes, I understand that, and I think that if the court believed that that was the appropriate way to craft presidential protections, it has the authority to craft procedural rules that implement its Article 2 concerns. That said, public authority we're calling it a defense, but under many statutes it's actually an exception to liability itself. And what you're really talking about is trying the general issue. And generally in criminal cases, even cases that involve First Amendment issues like threat statutes, the jury is the determinant of the facts. And I have a little bit of difficulty with the idea of trying the whole public authority issue separately to the judge and having that go up on interlocutory appeal with review of facts before you could ever get it forward into a criminal case. That said, if I would prefer a regime in which the court altered some of the procedural rules surrounding the president than a total, absolute blanket immunity that takes away the possibility of criminal prosecution, even if it was a core violation of the statute in the teeth of Attorney General advice and has no overriding public purpose.
You think it has to be a jury question? And I mean, let's see, I wasn't necessarily proposing actually treating it as a defense that was done at the outset and then subject to interlocutory appeal. I was proposing, what about an immunity doctrine that drew from the public authority defense that the Department of Justice thinks would otherwise apply? So just go with me on that for a minute. Why would it be so bad for it not to be a jury question? I mean, it seems to me that some of these Article 2 concerns would be exacerbated by having it go to a jury rather than a judge.
So I think some of them are judge questions that could be resolved on the face of the indictment. If the Department of Justice ever returned an indictment that said the issuance of this pardon or this series of pardons constituted obstruction of justice, I have a little difficulty hypothesizing it, but a motion could be made on the face of the indictment that says Article 2 precludes Congress from regulating these activities. The indictment needs to be dismissed. And if the court wished to attach to that kind of a rule interlocutory appeal, then that would be a lesser safeguard than the one that my friend is proposing here. Other kinds of defenses, though, really do intersect with the general issue. And for those, I have a much greater time seeing how the court could implement that. And would there be costs in going to trial? Yes. There is no perfect system here. We are trying to design a system that preserves the effective functioning of the presidency and the accountability of a former president under the rule of law. And the perfect system that calibrates all of those values probably has not been devised. I think that the system that we have works pretty well. Maybe it needs a few ancillary rules. It is different from the radical proposal of my friend.
I agree. Let me ask you about state prosecutions, because if the president has some kind of immunity that's implicit in Article 2, then that immunity would protect him from state prosecutions as well. a lot of the protections that you're talking about are internal protections that the federal government has, protections in the Department of Justice, which obviously are not applicable at the many state and local jurisdictions across the country. What do you have to say to that?
So that raises a Supremacy Clause issue, and the court would run a Supremacy Clause analysis that would probably start with basic principles like McCulloch versus Maryland. The states do not have the authority to burden federal functions, and would then kind of move through in Nagel, where the court said that a state murder prosecution of a federal official guarding a Supreme Court justice and who fired a shot was not permissible. If the court thought that you needed a more categorical rule for the states, I think the Supremacy Clause certainly leaves it within the court's prerogative to determine that the president, unlike all other officials, deserves more of a robust federal defense than what I have just described.
But it would still be a defense in the states. It wouldn't be, I mean,
well,
that's my point. Like, yeah. You know, it's one thing to say, well, the president, they're not going to be these prosecutions that are politically motivated, the things that Justice Kavanaugh was referring to that might be the danger of this system, one thing that we have to worry about. That might not carry the day, but, you know, that's a concern. It's totally different when you take it outside of the Department of Justice and its structures, and then you throw it out elsewhere. The idea across the states, the idea of an immunity, I think, has a lot more purchase if you're talking about something that protects the former president from standing trial and the state and local level.
So I don't know that you would have to design a system in which the president would have to stand trial at the state and local level. It's certainly within the court's authority as a matter of Supremacy Clause law to find an immunity. But we have been talking here about, at some length, on the distinction between official acts and private acts.
Yeah.
That will have to be determined by some sort of a process. Any immunity defense that the court announces can still be met by a state assertion that we're prosecuting private conduct. You're going to have some process. I think having some legal process is not a reason to cast aside a nuanced system that actually looks at what protections are necessary as opposed to what would provide the absolute maximum insulation for former presidents, even if we acknowledge that it's highly prophylactic.
Totally agree, and I wasn't actually contrasting the absolute immunity rule. I was saying that if there was some sort of official private, there are consequences towards about making immunity. Okay, and since you bring up the private acts, this is my last question. So I had asked Mr. Sauer about on page 46 and 47 of your brief.
Yes.
You say, even if the court were inclined to recognize some immunity for a former president's official acts, it should remand for trial because the indictment alleges substantial private conduct.
Yes.
And you said that the private conduct would be sufficient?
Yes.
The special counsel has expressed some concern for speed and wanting to move forward. So, you know, the normal process, what Mr. Sauer asked, would be for us to remand if we decided that there were some official acts immunity, and to let that be sorted out below. It is another option for the special counsel to just proceed based on the private conduct and drop the official conduct?
Well, two things on that, Justice Barrett. First of all, there's really an integrated conspiracy here that had different components as alleged in the indictment. Working with private lawyers to achieve the goals of the fraud, and as I said before, the petitioner reaching for his official powers to try to make the conspiracies more likely to succeed. We would like to present that as an integrated picture to the jury so that it sees the sequence and the gravity of the conduct and why each step occurred. That said, if the court were to say that the fraudulent elector scheme is private, reaching out to state officials as a candidate is private, trying to exploit the violence after January 6th by calling senators and saying, please delay the certification proceeding, is private campaign activity, we still think, contrary to what my friend said, that we could introduce the interactions with the Justice Department, the efforts to pressure the vice president, for their evidentiary value as showing the defendant's knowledge and intent, and we would take a jury instruction that would say, you may not impose criminal culpability for the actions that he took. However, you may consider it insofar as it bears on knowledge and intent. That's the usual rule with protected speech, for example, under Wisconsin versus Mitchell. My friend analogizes this to the speech or debate clause, but we don't think the speech or debate clause has any applicability here. It's a very explicit constitutional protection that says senators and representatives shall not be questioned in any other place. So it carries an evidentiary component that's above and beyond whatever official act immunity he is seeking. And the last thing I would say on this is we think that the concerns about the use of evidence of presidential conduct that might otherwise be official and subject to executive privilege is already taken care of by United States versus Nixon. That balances the president's interest in confidentiality against the need of the judicial system for all available facts to get to the truth. And once that has been overcome, we submit that evidence can be used even if culpability can't rest on it.
Justice Barrett?
So, Mr. Sauer, you've argued that the impeachment clause suggests or requires impeachment to be a gateway to criminal prosecution, right?
Yes, I think that's the plain meaning of that second phrase in the clause.
Okay, so there are many other people who are subject to impeachment, including the 9 sitting on this bench, and I don't think anyone has ever suggested that impeachment would have to be the gateway to criminal prosecution for any of the many other officers subject to impeachment. So why is the president different when the impeachment clause doesn't say so?
Someone very important has made the opposite suggestion as to the president himself, which is Solicitor General Bork, which is reaffirmed in the OLC opinions on this, where Solicitor General Bork in 1973, as to the issue of the vice president, reviewed the historical materials, and he said the sequence is mandatory only as to the president. That is DOJ's view of the original understanding of the impeachment judgment clause, which is exactly our position. The sequence is mandatory only as to the president. Keep in mind that the criminal prosecution of a president prior to impeachment contradicts, in our view, the plain language of the Constitution, but also hundreds of years of history, and what DOJ admits is the framers' intent. And so we say that that practice, whatever its validity, should not be extended to this novel context where it clashes with the constitutional structure.
What if the criminal conduct isn't discovered until after the president is out of office? So there was no opportunity for impeachment.
We say the framers assume the risk of under-enforcement by adopting these very structural checks. As Justice Scalia said in Morrison against Olson, the separation of powers prevents us from righting every wrong, but it does so that we do not lose liberty.
Okay, and the special counsel makes a point that I think is a pretty compelling one. You admit that if the president were successfully impeached, that he could be criminally prosecuted after impeachment, right?
Assuming the prosecution was for the same conduct of which he was convicted, not impeached, he must be convicted. That word conviction is right there in the clause.
Okay, granted. But you also say that these criminal statutes, unless they explicitly mention the president, don't apply to him. So how can you say that he would be subject to prosecution after impeachment while at the same time saying that he's exempt from these criminal statutes?
Well, there are statutes, as they concede, where Congress has purported to do so.
2 or 3.
They haven't done a comprehensive review. I think it looks like all they did was text search for president in 18 U.S. Code. Again, under Franklin, that's a very telling indication that the word president is not in the statute. It isn't necessarily a magic word requirement, so to speak. But more fundamentally than that, they concede there are statutes that exist. In addition to that, much impeachment could occur as a result of private conduct. So the impeachment judgment clause does do significant work by authorizing the subsequent prosecution of a president there, because what the framers, if you look at what they're discussing in the thing, or in the Constitutional Convention, is principally concerns about private conduct, which of course we concede are not immune.
Okay, so just to pick up Justice Kagan's example of a president who orders a coup, let's imagine that he is impeached and convicted for ordering that coup, and let's just accept for the sake of argument your position that that was official conduct. You're saying that he couldn't be prosecuted for that even after conviction in an impeachment proceeding if there was not a statute that expressly referenced the president and made it criminal for the president.
There would have to be a statute that made a clear statement that Congress purported to regulate the president's conduct.
Okay, thank you.